Very competent teams. For the appellants, we have Mr. Arnett Sundaraj, Mr. Daniel Feldman, and Ms. Davina Yatharan. And appearing for the respondents, we have Mr. Justin Morini, Mr. Dion Rocky, and Ms. Kate Bolster. Tonight, the bench consists of 4 members acting as judges. We have the Honourable Mr. Justice Hayne from the High Court of Australia, the Honourable Mr. Justice Phillips, Chief Justice of the Victorian Supreme Court, the Honourable Justice Vincent from the Supreme Court of Victoria also, and Mr. Stephen Parker, the Dean of the Monash Law Faculty. Tonight's moot should finish at approximately 9:30, depending on how long the competitors go for. After that, everyone is welcome to come across to the Essendon Club, which is on the 13th floor of Dixon Chambers, across the road, 205 William Street, where there will be a presentation ceremony, refreshments will be served, and the winners will be announced. There will be plenty of LSS committee people to guide you across the road. It's not too far a distance, and we hope you can make it there. Finally, I'll just ask you all to turn off any mobile phones or any other such equipment that you might have, and I hope you have enjoyable evening. The judges will be coming out in the next few minutes, so hope you have a good evening.
All persons having business before this honourable court are commanded to give their attendance, and they shall be heard. God save the Queen. Be seated. Kranz and Joseph Kranz, and Roberto Paglia and Felicia Paglia.
Counsel and other appearances.
May it please the Court, my name is Daniel Feldman and I appear as Senior Counsel for the appellants in this matter with my learned junior Arnett Sundaraj. We will both be speaking for 20 minutes, and with the Court's pleasure we reserve time for rebuttal to be instructed by the benefit company.
Yes, Mr. Feldman.
The Court pleases. My name is Justin Morini. I appear with my learned friend Mr. Morocchi on behalf of the respondents. Both Mr. Morocchi and myself will be speaking for 20 minutes.
Thanks, Mr. Morini. Yes, Mr. Feldman.
Your Honours, on the face of it, this case involves a number of difficult and technical legal issues, and indeed the length and the depth of the memos before you attest just to how complex this case is. And I realise that my time is short, so I'll try and move further through those issues as quickly as possible. In our submission, Your Honours, this case is fundamentally about the intention of Parliament and the property law to prevent dishonest people from obtaining an unimpeachable title to land. In our submission, this intention is manifested both in the provisions of the Transfer of Land Act and in the provisions of subsequent statutes which have a negating effect on indefeasibility within the Transfer of Land Act. In seeking to use tainted property to deprive our clients of their hard-earned property, it is submitted that the respondents have lost the benefits which normally accrue to a registered proprietor of property, namely the benefits of indefeasibility. To that end, Your Honours, I will first show that indefeasibility provisions within the Transfer of Land Act do not apply to this case, as they have been superseded by subsequent legislation, namely the forfeiture order provisions in the Confiscation Act. I'll demonstrate in the alternative that the fraud of both respondents has vitiated their title to the property to the extent that they do not receive an indefeasible title to the property, and indeed the title is defeasible upon the claim of our clients. My learned junior will submit in the further alternative The fraud of Helpful Harry, who is the agent of the respondents in this case, may be imputed to the respondents, but as such, their title is again defeasible. You will also submit that our clients hold certain rights in the Stone Act against the respondents, which arise from unconscionable dealings by the respondents with our clients. Finally, he will contend that there never was a valid mortgage contract in this case, as there was no contract sufficient to pass an interest in land, and that as such there's been no consideration in law for the mortgage. The respondents are therefore volunteers and do not gain an indefeasible title. So to please the Court, I'll move to my first submission, which regards the inconsistent legislation. In our submissions, Your Honours, there are two statutory concepts which are central to this case, and they are mutually exclusive and inconsistent. The first concept is that of indefeasibility under the Transfer of Land Act, which is provided for in Section 42. The Transfer of Land Act, of course, applies the Torrens system of land registration to Victoria. Under Section 42, a registered proprietor's title cannot be impeached by anybody except in the case of fraud against the person who originally had the title. This means that, for example, defects or flaws that occurred prior to registration, either in the processes or the instrument itself of registration, may well be cured once the document itself is registered and the title is gained. This can lead to some very difficult situations for the court to resolve, where a registered proprietor who has acted morally or unlawfully can still gain a clean title. The second central concept in this case is that of the forfeiture order under the Confiscation Act. And the forfeiture order seeks to limit the occasions when a registered proprietor may gain an indefeasible title. Specifically, it prevents criminals from using proceeds of crime to gain a title to property and thereby launder the money by having an indefeasible title which cannot be touched by anybody.
But those are general statements, aren't they, about what you say are the purposes of the two acts. At some point you've got to come to grapple with the words of them, don't you? And see how they work together.
That's correct, John. We submit that there are two principles which guide the court in reconciling these inconsistent statutes, and those are found in the leading case of Forbuck and the Commonwealth Bank of Australia.
And there is nothing essentially inconsistent between the notion of indefeasibility of title on the one hand and confiscation of the property in respect of which is an indefeasible title on the other.
Our submission, Your Honour, is that the effect of the Confiscation Act is to void any registration which is procured with the proceeds of crime. As such, we would submit that this is inconsistent with indefeasibility, which provides that no person may impeach the title of a registered proprietor.
That takes up the point that Justice Haynes was referring to. It's necessary to go beyond these notions of broad inconsistency because, as I said, it isn't necessarily inconsistent with the notion of indefeasibility of title that there should be confiscation of the very property which is the subject than otherwise indefeasible title.
In our submission, Your Honour, it's necessary that the indefeasibility provisions of the Transfer of Land Act be subjected to the Confiscation Act, because otherwise the Confiscation Act cannot operate. In Victoria...
That's making, is it not, an a priori assumption about the reach of the confiscation. Now, haven't we got to begin by grappling with the words of the Act, seeing what its reach is, and then going up?
Certainly, if Your Honour would like, I can certainly point to some examples of the words of the statute which on the true meaning are...
I don't think that's our job, I think that's yours.
Yes, certainly.
Especially where we don't have the right to go.
One of the principles that was evinced by Justice Ormiston in the case of Forbuck was that in order for legislation to be inconsistent, there must be, on the true construction of the words in the statute, some inconsistency. In our submission, there is clear inconsistency between provisions of the Confiscation Act, substantial provisions of the Confiscation Act, and substantial provisions of the Transfer of Land Act, and I'll move those down. Under Section 42 of the Land Act, the only statutory exception to indefeasibility is for fraud. There are a number of common law exceptions, but the only statutory exception is fraud. Those are the words of the statute. Sections 41 and 42 of the Confiscation Act negate this to some extent, because they in effect create other exceptions.
What do they say?
Section 41, Your Honour, vests all property that is subject to a forfeiture order in an equitable sense in the minister, in the relevant minister. So a registered proprietor who may nominally be the owner of the property, nevertheless is not the owner of the property once it is found by the court that the property is being derived from proceeds of crime.
No, what that says is what it says, that if there is a confiscation confiscation order, it's vested in a particular person.
That's-
It doesn't say anything about the defeasibility of the title of the previous holder, of the actual owner.
In our submission, the effect of that provision is to render indefeasibility null. Indefeasibility is, on the face of the statute, on the face of the Transfer of Land Act, is only accepted by fraud. That is the only statutory exception. This, in effect, creates another exception. It creates an exception when property has been derived and registered and procured by virtue of the process of crime.
Explain that to me, you see, as I said to you before, why is there some notion of inconsistency between these two concepts? You could say that that was unequivocally mine. I bought it. True, I bought it with the process. But it is not. Somebody then says, because you bought it with the process of crime, we will confiscate it. That doesn't impinge in any way upon the feasibility or indefeasibility of your title. It simply says that we're going to take it.
The Act does provide, Your Honour, that once a forfeiture order has been made over the property, the registrar must make appropriate amendments to the register. Effectively what happens is the equitable title vests immediately in the minister, and then the minister must follow certain guidelines to return the property to its rightful owner. Essentially then, what occurs once the property is found to be subject to a confiscation order is that the registration is effectively null. In an equitable sense at
Well,
least.
it's null, or is it simply that A owns property and the Crown, the state, government comes in and says, well, you may own it now, but guess what? You're giving it to me. Confiscated. Is there any more sophisticated concept than that? What's yours? I'm taking.
Our submission is largely based on the view that indefeasibility provides for a very limited range of exceptions. Indefeasibility will make a title unimpeachable and indefeasible, except
you
where...
see, what you're being challenged with is an argument put to you that this is not a question of indefeasibility at all. This has nothing to do with the feasibility as a question. This has to do with possibly an acceptance of that it is indefeasible. We don't care if it's indefeasible. You have obtained this property as a consequence of criminal activity, so we're going to take it off you. That is a different question.
Essentially, Your Honour, I think the dispute here is whether the respondent's title can be vitiated by virtue of the fact that it was subject to a confiscation order. That is the issue at hand here. In order for that issue to be made out, what must be shown is that the indefeasibility provisions are somehow subject to a confiscation order. That an indefeasible title, that an otherwise indefeasible title can be made defeasible or void or otherwise not indefeasible by virtue of a confiscation order being over the property in question.
What do you understand as this notion of indefeasibility?
Indefeasibility, Your Honour, falls within the principle of the Torrens system providing title by registration.
What does it mean?
It means that a person who owns property a person who is the registered proprietor of property gains a title that is free from all other interests except in the case of fraud. And where under section 44, subsection 1 of the Transfer of Land Act, a person who has committed fraud has a void title. The title is defeasible as against the void party.
Does this mean that they are to be treated as never had been had title to it before?
It is actually, in our submission on the face of the Confiscation Act, a difficult thing to say. On the face
No,
of
I'm not talking about the confiscation. I'm talking about the way in which this notion applies in relation to the foreign system. Does it mean that you are treated as if you never had that interest because of this fraud that you have embarked on? It is as if what occurred didn't happen.
No, Your Honour. The effect of it is that the title is still good against all the people in the world except the person who holds a claim of defeasibility over the title.
But against that person, is it as if it never occurred?
That's a difficult question to answer. In our submission, it would probably...
Don't you have to answer?
Your Honour, we would submit that, in a sense, no, it's not necessary to answer that question because the effect of the Confiscation Act is different to the ordinary effect of defeasibility by virtue of the concept of fraud. In our submission, Your Honours, the issue at point here is whether the two statutes are inconsistent on their terms and whether they can be read together. That is the basic question here. If, in our submission, if the statutes are read together, both on the meaning of the terms or looking at their aims and the general operation of the acts together, there is going to be an unpalatable result. In our submission, Section 41 of the Confiscation Act is inconsistent with indefeasibility. But more than that, Your Honours, if the indefeasibility provisions of the Transfer of Land Act are not subject to the Confiscation Act, then the Confiscation Act simply has no effect. And so, as a matter of law, it must be taken that Parliament had the intention with the Confiscation Act to amend or repeal the relevant provisions of the Transfer of Land Act to the extent that they are inconsistent with the Confiscation Act. So, in a sense, it is not a question really whether the indefeasibility provisions of the Transfer of Land Act are made defeasible or are made null or void, or indefeasible title is made defeasible or null or void. As a matter of law, it is submitted that the provisions of the Transfer of Land Act which relate to indefeasibility simply don't apply in this case because they've been repealed as a question of law. That is the submission we're trying to make in this case. The reason that they are inconsistent, and I realise my time is running down, I'll move quickly, is that if they are read together, what will occur is that the Confiscation Act is simply useless. The Confiscation Act is designed to prevent people from laundering money. It defines money laundering under Section 122 as knowingly participating in a transaction involving the proceeds of crime. That is exactly what has happened in this case. The respondent has knowingly participated in a property transaction when he knew that the proceeds of crime were being used in that transaction. This is precisely the thing the Confiscation Act is designed to stop. The Confiscation Act is designed to stop people hiding behind an indefeasible title. People in Victoria can hide behind an indefeasible title by using the proceeds of crime to gain it. And that would mean that a very large percentage of real property in Victoria cannot be subject to the Confiscation Act. A very large.
What, very large?
A very large.
In Victoria, it's been a criminal activity. They're not householders, they'd be worried about that.
Certainly the intention of Parliament is that that doesn't happen, and that's why the Confiscation Act has been passed, Your Honours. It is conceivable, rather there is no conceivable way that this actually read together in that light, in the light of the fact that if an indefeasible title will allow a criminal to get away from the consequences of using the proceeds of crime, the Confiscation Act has no effect. If it does have effect, and I note that in this case, the $44,000 that was advanced by the respondents is subject to a forfeiture order under the Confiscation Act. If the court were to look away from the mortgage itself, away from the title, and to go after the $44,000, which in our submission would be contrary to the intention of Parliament, then what effect would that have on our clients? First of all, they would lose their home by virtue of the indefeasibility provisions. Secondly, they would lose the $44,000 by virtue of the forfeiture order. In effect, our clients would have suffered a double injustice, whereas the respondents who have obtained the title by criminal activity would get away with a clean title. That cannot be the intention of Parliament. And
well, isn't a real nasty problem that you've got in front of this? Your client borrowed $44,000. Let it be assumed the Confiscation Act works. Let it be assumed it bites. What it bites on is the mortgage of the alleged wrongdoer. Why does that free your client from the obligation to pay to the confiscating party, namely the state, the $44,000 which was borrowed?
It doesn't, Your Honour. The money would still be subject to the forfeiture order. It would still be money that our clients are not entitled to have. But the effect of reading the indefeasibility provisions with that, and in fact subjecting confiscation orders to the indefeasibility provisions, is that first our clients would lose their home to the respondents who have gained it with the proceeds of crime. And secondly, they would lose the $44,000 to the forfeiture order. So in effect, they'd suffer double injustice, and the criminals in this case would in effect get away with a clean title to a home. That double injustice is something.
I'm sorry, I'm doing one step behind the argument. What is it that's forfeited under the confiscation?
In our submission, what is intended to be forfeited is both the property derived from the proceeds of crime, which is the mortgage, then the mortgage is left alone, and all that is returned is $44,000. Our clients are left with nothing. The respondents have a clean title to a home, and that is a double justice in our submission.
The Court of Appeal.
The mortgage had been registered, so the court did not consider whether that was also taken. I know my time is running down. If I can quickly move to the question of fraud. If the court does...
Before you go on, will you just tell us what you say that Horvath's case stands for in terms of your argument?
In our submission, Your Honour, Horvath's case stands for the principles which which guide the court in the reconciliation of inconsistent legislation. Justice Ormston in that case drew together all the threads of English and Australian authority, including authority of this court, and laid down some fairly clear principles, namely that the acts read together must be so repugnant that they cannot stand together. We submit that they are by virtue of either the uselessness of the Confiscation Act or the double injustice, and further that the words of the statute must be inconsistent. He also considered that Parliament's intention.
The words of the statute.
The words of the latter statute must effectively negate the operation of the former statute. So moving briefly to fraud, Your Honours. If the court does find that the statutes are not inconsistent or are not repugnant in this matter, it's submitted that the respondents still have no infeasible title because they've both been fraudulent in their dealings with our clients. It's well established that fraud will render the title of a registered proprietor defeasible as against the person who is defrauded, and indeed Section 42, which I have extensively related to this court, does contain that exception. So what must be shown in this case is that both respondents have been fraudulent. The question of what is fraud was proclaimed by this court in the case of Barr and Nicolay in 1998, which was reported in volume 164 of the Commonwealth Law Reports at page 604. According to the court, fraud imports something in the nature of dishonesty or moral turpitude, not mere disregard of rights. I briefly note that in their respondents, the respondents seem to suggest that Section 44, subsection 1 of the Transfer of Land Act, limits the definition of fraud to fraud which is operative against the registrar, to fraud which occurs at the actual lodging time of the document to be registered. That reading of Section 44.1 was considered by the Honourable Justice Haynes then was in the case of Vassos and the State Bank of South Australia, which was decided in 1993 and reported in Volume 2 of the Victoria Court, page 316. Your Honours, I do know my time has expired and I have a brief moment to wrap this.
Did the Court of Appeal find the respondents had been jointly and separately fraudulent?
In the case of Vassos, Your Honour? In the case of Vassos.
Did the Court of Appeal find that the respondents had been jointly and separately fraudulent?
It found that they had not been fraudulent. In our submission, however, the court was wrong in that.
What ground of appeal attacks that? What ground of appeal attacks that finding?
So we quickly refer to Part 2, Your Honour, which states that the mortgagees were fraudulent and obtained registration do not acquire an indefeasible title under Section 42 of the Transfer of Land Act. Again, I do know
they were fraudulent as a matter of law.
In our submission, they were fraudulent as a matter of fact and a matter of law, yes. Mr. Parlier has been fraudulent, Your Honours, very quickly, because he has dishonestly used tainted money to represented it to our clients as clean money both he was entitled to use and money that our clients was entitled to keep. They have relied on that and granted a mortgage, and as a result of that, may lose both their home to the indefeasibility provisions and may lose the money which is subject to a forfeiture order. There is no clearer definition, no clearer example of what is fraud than what respondents have done in representing the money the way they have. That is the fraud of Mr. Parlier. Mrs. Parlier has been fraudulent in our submission because she has been willfully blind. The Privy Council in the leading case of the Privy Company and Mary Roydy established that willful blindness was a form of fraud and occurs when a person has suspicions or should have held suspicions about certain transactions but did not make further inquiries for fear of learning the truth. In this case, it is submitted that Mrs. Parlier is guilty of willful blindness because, first of all, she knew she was entering into a mortgage, she knew that $60,000 was involved, that's a substantial amount of money. She must have questioned where the $60,000 came from. If she didn't question where the $60,000 came from, what are we to think of her motivations? She must have, in our view, at least questioned or ought to have questioned where that $60,000 came from. and as a result of her not making further inquiries of her husband, she is willfully blind, and his fraud is, in a sense, imputed to her. Are there no further questions?
Thank you.
If it pleases the court, I'll be making 3 submissions on behalf of the appellant today. Firstly, that fraud has been committed against the registrar by an agent of the respondents. Secondly, that the appellant is entitled to a persona claim for unconscionable dealing. And finally, that as a result of the contract being void, the appellant, the respondents are volunteers, and the appellant is entitled to have the mortgage set aside. If it pleases the court, I'll turn to my first argument that fraud had been committed against the registrar. In Diego and the Registrar of Titles, cited in 1994, reported in Victorian Law Reports at page 483, a registered mortgagee claimed possession against 2 mortgagors, Mr. and Mrs. Diego, who were the registered joint proprietors of the Torrens land. A default judgment was obtained against Mr. Diego, but the action...
Before you get into the detail of the case, you might be good enough to tell us what it stands for in terms of your argument.
Certainly, Your Honour. It is submitted that the case of Diego stands for the proposition that false attestation of a transfer document, which is registered, to the knowledge of the new registered proprietor is fraudulent. Justice Tadgell in the Supreme Court held that the requirement of dishonesty is not needed in such a case because to lodge an instrument for registration in the knowledge that the attesting witness has not been present at the execution must deprive the lodging party of an honest belief that it is a genuine document on which the registrar can properly act. And that was said at page 498, which is highlighted for your honours in the transcript provided. The wife's, Mrs. Diego's signature on the transfer had been forged, and the mortgagee's employees were aware of this, yet they attested the signature and registered the mortgage. Justice Tadgell held that the actions of the employees in allowing the instrument to go forward for registration, knowing that it had not been properly attested, amounted to fraud within the meaning of Section 42 of the Transfer of Law Act.
It was not properly attested. They knew that it was a lie.
Your Honour, I don't believe in that case that the employees of agency did know that the signature had been forged in that case. They merely noticed that it lacked an attestation, and one of the employees signed, effectively saying that he had witnessed Mrs. Diego sign, which had not occurred, and then it was registered. Counsel for the mortgagee in that case admitted that mere lack of attestation does not amount to fraud, but it was just a mere formal irregularity. Justice Tadgell rejected this proposition, holding that the lack of signature of an attesting witness to an instrument to be registered under the Transfer of Land Act is not a mere formal irregularity. It amounts to fraud. He stated that a system of land title by registration, such as the Torrens system is, plainly depends on the good faith of those presenting instruments of registration. He implied into Victorian statute that there was a requirement of attestation. Similar requirements appear in all the other jurisdictions in Australia.
Well, how does that apply here?
It is submitted, Your Honour, that the court should make the same finding in this present case. The Crown says the appellants in this case did not have their signatures properly attested. A student in the employment of the agent of the respondent in this case falsely attested their signatures, and this...
It's the intervention of the agent. It's the hurdle you have to pass over, is it? Why can you attribute the act of the helpful student to the registering party?
Because the student who did attest the document was in the employment of Helpful Harry, who was the agent of the respondents in this case, Your Honour.
The person whose title you seek to impeach is someone whose title you impeach by what and
his employee, the student, are no different to the actions of AGC and their employees in the case of Diego. The helpful Harry was acting within the boundaries of his scope of authority when he went ahead and sought the signature of the appellant on the mortgage document to be registered. And anyone acting for him, or anyone in his employ, in this case, the student undertaking work experience, is also within his, any of their actions are within.
It just seems to be a different level of debate. To saddle an employer with the knowingly dishonest conduct of the employee is one thing. To saddle a registering party with the honest but misguided conduct of somebody engaged, using a neutral term, by an agent of that registering party seems of a qualitatively different order.
Your Honour, helpful Harry was acting under instructions of the respondent in this case to go ahead and execute the mortgage. Since the student engaged in his employment, did have access to that is correct, Your Honour.
You have to show, in order to support round 2, the finding other than that they were fraudulent was not open on the evidence, don't you?
Your Honour, in Justice Tadgell's formulation in Diego, dishonesty was not a requirement. The mere fact that a signature had been falsely attested was dishonest enough to prove fraud in that particular case. Another case of the Supreme Court, which was decided more recently, which the respondent relies upon, Russo and Bendigo Bank and Reichman, is similar in some respects to the present situation. In that case, the court required that there was some amount of dishonesty. And if it pleases the court, I'd like to go through the facts of that case in order to distinguish it from the present and also establish that there was dishonesty on the part of the respondent's agent, Harry. It is submitted that the registrar has been defrauded in this particular case because a document which has been dishonestly attested to has been registered, thereby giving the respondent an indefeasible title.
Is the reference to any person frauded in section 44 when the reference to the register?
Apologies, Your Honour, may
Is the reference to any person defrauded or sought to be defrauded in section 44(1) include a reference to the registrar?
I don't believe it does, Your Honour. We seek to rely on section 42 of the transfer agreement.
So you say, how do you say that consent?
Because a document that has been dishonestly attested has been registered, thereby giving the respondent an indefeasible title. If I may continue with Russo. In Russo, Mrs. Russo's signature had been forged by her son-in-law in order to secure a loan from the Bendigo Bank. Her signature had been falsely attested by an employee of the bank's solicitor, Rita Gerardo. Mrs. Russo appealed to the Supreme Court of Appeal, claiming that fraud could be imputed to the Bendigo Bank through the agency of their solicitor, Mr. Reichman. However, the appeal failed because the forgery could not be imputed to Mr. Reichman in that case. Mr. Gerardo was authorised by Reichman to witness signatures and was sternly instructed never to attest a signature which he had not personally witnessed. It is submitted that these facts differ from the present case, firstly because the student engaged by helpful Harry in work experience, unlike Mr. Gerardo, was not on the facts authorised to attest signatures. And secondly, even if the student was authorised to do that, to do as she did, helpful Harry did not strictly instruct her, as Mr. Reichman, the solicitor in Russo's case, had, to never attest a signature unless it had been personally witnessed. Furthermore, it is submitted that helpful Harry was deceitful, or at least dishonest, which is a further requirement of fraud for the purposes of the Transfer of Law Act and Land Act.
was this, leave aside the witness, was this document signed by the persons who purported to sign it?
Yes, it was, Your Honour. It is considered that there was no forgery in this particular case. However, it is submitted that Justice Tadgel's opinion in De Jager still stands that it is dishonest to submit a document to the registrar without knowing that it's been properly signed by the registered proprietors. If I may continue, it was Helpful Harry who had dealt with the communications between the appellant and the respondent. He collected the blank mortgage transfer, which had been signed by the appellants, and at that stage it should have been obvious to him that the appellant's signatures had not been attested. At the very least, it should have been apparent to him when he went ahead and actually filled in the details of the blank transfer that there was a lack of proper attestation. It is important to note that Helpful Harry did have a motive to push through the transaction, knowing that it had not been properly attested to. The facts state that he was to be sufficiently remunerated for the transaction, and it is submitted that he did not care whether the appellant's signatures were properly attested because he was going to get paid this sufficient remuneration. And also, his time and cost were minimised by ignoring the appellant's attestation, by ignoring the attestation requirement and going ahead with the registration. Harry was aware that the appellants had no knowledge or experience of mortgage transactions. The appellant had agreed to pay an enormous interest rate, well in excess of 30%, and repayments in 4 large instalments. These are both very unusual features of a mortgage. Harry must have therefore known that the appellants were naive to the fact that they were being effectively swindled. His actions were fraudulent. It is these crucial differences that distinguish the present case from that of Russo. Helpful Harry took no precautionary steps to prevent the registration of a document not properly attested to, and he was deceitful. The mortgage which was registered was therefore done fraudulently, and because there has been fraud against the registrar in this case, the respondents do not gain an indefeasible mortgage. Therefore, it is submitted that the transaction should be set aside.
Is this situation stronger or different from that in Russo? In Russo, of course, as I understand it, the signature which was being in relation to no proper attestation was not a genuine signature. But because various instructions and protections in the article put in place, that was regarded as okay. Here, we actually have genuine signatures. Why would that not be a stronger situation?
It is submitted that this particular case is fraudulent, Your Honour, for the reason that because in Russo there was the warning never to falsely attest, and in this case there wasn't.
But here, you see, Russo finished up with the situation, there wasn't a genuine signature at all.
Yes.
Here we actually have genuine signatures. Now, the real purpose of this protection is to ensure that you do have genuine signatures. That's what we've got. Everyone accepts that. Why is this not a stronger case than Russo?
Your Honour, the reason is because apologies, I've lost my train of thought. In Russo's case, the signature was fraudulent, yet the solicitor had warned the person responsible for attestation never to do as she did. In this case, although the signatures were genuine, Helpful Harry nor the student had no way of knowing that they were
I
genuine.
have trouble in coming to terms with the notion that because you instruct someone to be careful about doing something which is not real, and turns out that contingency comes to pass, you're in a better situation than if in fact the signature was real.
I would agree with Your Honour that the case in Russo does have certain flaws from that perspective because the signature was a forgery. But the appellant seeks to rely on the judgment of Justice Tadgel when he said that the very fact that attestation was false does mean that there was dishonesty on the part of the new registered proprietors. Does that satisfy Your Honour at all?
No.
It is very difficult to reconcile.
One view of what Justice Tadpole was saying with the ABC and Viaga is that there is fraud if you submit for registration a document that is telling a lie. It tells a lie if it says signed in the presence of J. Smith and J. Smith was not there when it was signed. Now, unless you can maintain the general proposition that that equals fraud, it seems to me your argument may be in some trouble. But is that the generality of proposition you advance?
Yes, it is, Your Honour. That is the proposition that we rely upon to volunteer in this case.
So yes, you can say that because it's consistent with the entire notion of registration. It's necessary to rely upon these kinds of materials. So if you tell it lies in the documents that secure registration, well, that's your trouble.
Well, it is fraud, Your Honour.
What loss does the registrar suffer? How does the registrar do anything different than he or she would have done had the document been properly witnessed?
Well, in the circumstance of this particular case, it is probably arguable that there would be no difference. But the very fact that there was a dishonest attestation means that there was fraud in this case.
So dishonesty equals fraud,
In the words of
irrespective of
Justice
consequence.
Tadpole, if I may,
Fraud equals no indefeasible taint. That's as simple as that.
that is correct. If I may move on to the second argument, that there is an impersonal claim which the appellant possesses in this case. It is well established that a right in persona or a personal equity is a recognised exception to the feasibility of title under the Transfer of Land Act. According to Justice Powell in bringing the ANZ Banking Group, a right in persona encompasses all legal causes of action and all equitable causes of action. It is submitted that in the present case, the appellants have a right in persona for unconscientious dealing against the respondents. Unconscionable dealing scrutinises the conduct of the stronger party in its dealings with a person under a special disadvantage or disability. It should be contrasted with the remedy of undue influence, which looks to the quality of the assent or consent of the weaker party. Unconscious dealing was discussed in the leading case of this court, Commercial Bank and of Australia and Amadio. In that case, the court held that the respondents, the Amadios, were entitled to have a mortgage over their property set aside on the grounds that the appellate bank was guilty of unconscionable dealing. The court focused on the position of the respondents as being in a position of disadvantage vis-à-vis the bank. The relevant circumstances of that disadvantage was the following factors. The fact that the respondents had a limited grasp of written English, that the circumstances in which the bank presented the mortgage for their signature, their lack of understanding of the contents of that document, and their dependence on the son for whose benefit the mortgage was taken out for guidance and advice.
And that was the real nasty in the market, wasn't it? Parents who did not have a grasp of English and understanding of what was happening suddenly found their house mortgaged for son's debts.
That was certainly one of the factors, Your Honour, but Justice Mason said that there was no necessity that the transaction be taken for another's benefit. It was stated that the transaction should benefit the weaker party. In a particular case, it was not necessary that the consideration flow to a third party as it did in the Amadio's case.
But in its most general and broad terms, what is it that is rough or smelly about this transaction? Put it in as broad, colloquial terms as you like.
Certainly, Your Honour. The disability suffered by the appellants is a combination of factors. That they were migrants, as were the Amadios, whose first language was not English. They were unaccustomed to commercial transactions and had no previous experience in mortgages. They relied on the advice of Carol Pollack, as the Amadios had relied on the advice of their son Vincenzo. And further, the concept of taking a mortgage out on their home, as stated in the facts, was something quite foreign to them. It is submitted that, therefore, the situation of the appellants in this case is substantially similar to that of the Amadios, that Helpful Harry, as the agent of the respondents, and the respondents themselves, the position is similar to that of the banker in that particular case.
But the appellants came to grief because Mrs. Krantz became seriously ill. One of the vicissitudes of life has come along. They weren't taken advantage of. Something very unfortunate.
Your Honour, it is submitted that they were indeed taken advantage of. Her special disability did not actually include a sickness at the time, because at the time of signing the mortgage, she was
Who took advantage of it? And how?
Helpful Harry took advantage of their situation, their naivety in not realising that mortgages generally don't have 30% interest rates and they don't usually have large $15,000 repayments due. He was aware, he was referred to the appellants by Mr. Pollack, a friend of the appellants in whom they placed great trust. There is nothing on the facts that states that Helpful Harry had any reason to think that the appellants had received advice on the mortgage from anyone but Mr. Pollack. And considering, as I stated earlier, the unusually large sums of repayment required and the large interest rate charged, it should have been clear to Helpful Harry that the transaction was improvident from the viewpoint of the appellants. Further, the fact that the appellants had signed a blank mortgage document, a blank mortgage transfer, is additional evidence of their naivety. Helpful Harry, having dealt with a number of mortgages in the past, have been quite aware of the fact that this is very odd for someone undertaking a mortgage to put their signature on a blank document.
Well, as they say in another place, the honourable member's time has expired. If you get another go, you might tell us which ground of appeal the in persona argument relates to.
Certainly, Your Honour, I will allow our member to come up to the final.
Thank you. And now, Mr. Merritt.
There are two grounds of appeal. The court has received our written submissions. I will deal with the second ground of the appeal in relation to the alleged fraud, written submissions 1 through to 6. And Mr. Morocchi will deal with the first ground of appeal in relation to the Victorian Transfer of Land Act and the Victorian Confiscation Act, written submissions 7 through to 9.
Does that mean
the question which falls to be determined in this case is whether the respondent has an infeasible title. Your Honours, we submit actual fraud within the context of the Act. The respondent has an infeasible title. If the appellants are to impeach the title of the respondents, they must establish on balance of probabilities that the respondent procured their title in a fraudulent manner. We submit that under the Torrens system, fraud in the context of the Act is a statutory exception to the doctrine of infeasibility. It is a unique concept that is not totally equivalent to the common law or equitable doctrines of fraud. Fraud in this context...
So describe it.
Sorry, Your Honour?
Is the court so describe it as a unique concept?
That's correct, Your Honour. Fraud in this...
which court?
The High Court, Your Honour, in the recent judgment.
In any particular case?
I'm moving to that now. We submit that fraud in this context is an exception to infeasibility only where the registration was procured by fraud. The relevant principle is to be found in the High Court decision of the Bank of South Australia and Ferguson, which was decided in 1998 and recorded in volume 192 of the Commonwealth Law Report at page 248. Your Honours will find that applying tab 2, Part A, Part A, tab 2 of our authorities.
Both of your
judgment of Justices Brennan, Galdron, McHugh, Gummo and Kirby, stated at page 255 towards the bottom of that page, that not all species of fraud which attract equitable remedies will amount to fraud in the statutory sense. The distinction may be illustrated as follows. In some circumstances, equity subjects the interest of a purchaser of unregistered land to an antecedent interest of which that purchaser has notice of. However, the court in Ferguson unanimously recognised at page 255 that in respect of land to which the Act applies, registration of a transfer is not fraudulent in the statutory sense merely because the transferee has notice of that interest and knowledge that registration will defeat that antecedent unregistered interest. The relevant principles are sections 42 and 44 of the Transfer of Land Act. Section 42 provides a general rule of infeasibility subject to an exception in the case of
law. The expression a unique concept appear in any of the cases?
Section 42 or?
No, in any of the cases.
Which expression?
Does the expression that statutory fraud is a unique concept appear in any of the decided cases?
Yes, Your Honour. It does. It states so in...
Or is that your conclusion that you would seek to draw from it?
That is our conclusion from all the authorities that we will present for. Section 42 provides a general rule of infeasibility subject to the exception of fraud. Section 44, subsection 1, provides that, and in particular, the words any folio of the register or amendment to the register procured or made by fraud. We submit that section 44, subsection 1 stipulates the consequences that flow in the instance of fraud. And this is a unique provision to Victoria, Your Honour. And based on this reasoning, Your Honour, Justice Hay, in Vassos's case, said at page 326 that it is clear that section 42 is now to be read as providing for an exception to indefeasibility only in cases where the registered proprietor obtained registration by fraud. And in the recent case of Pyramid and Scorpion Hotels, decided in 1998 and reported in volume 1 of the Victorian Reports at page 188, Your Honour, Justice Hayne, as a member of the Victorian Court of Appeal, and with whom Justices Tadgell and Brooking agreed, reaffirmed this approach to the Victorian Transfer of Land Act.
For those of us who moved there, what's it mean?
Sorry, Your Honour.
What is this fraud that will affect
The fraud amounts to...
infeasibility type in this context?
We submit that fraud in this context is simply not the actual signature falsely attesting to the document, but taking that false attestation to the Registrar of Titles and representing to the Registrar of Titles that this is a true and genuine document that the Registrar could effectively act upon.
So fraud is a fraud with respect to the registrar. It's got nothing to do with anybody else.
That's correct, Your Honour. We submit it must be established on a balance of probabilities that the registered proprietor or his agent has committed actual fraud. Equitable or constructive fraud does not suffice. In the most recent decision in relation to the Act, the decision of Russo and Bendigo Bank Limited, which was an unreported decision of President Winnicky and Justices Ormiston and Batt, and delivered on July 30, 1999. In dealing with the very issue as before this court tonight, namely the nature of this statutory fraud, the Court of Appeal, at paragraph 26 and a long line of other courts before them, started with the decision of the Privy Council in Assets Company Limited and Nia Rowie, which was decided in 1905 and reported in the appeal cases at page 176.
Does the taking of a document to the registrar which is not properly been attested satisfy your testimony?
That's correct, Your Honour, it does. On the facts of this case, it clearly does.
So So you say merely presenting the document to the registrar in this situation should avoid fraud.
That's correct, Your Honour. The essence of our submission is that fraud within the Act is the statutory fraud amounts to actual fraud, which comes down to dishonesty, and dishonesty is equated with conscious impropriety on the person, on the part of the person who lodges that document for registration. And on these facts, the respondent will show that the employee of Honest Harry was not dishonest, and it was her who set the registration in motion towards the registrar of titles.
So, but is she dishonest?
She's not dishonest. We submit that she
Who's dishonest?
We submit no one's been dishonest within the statutory meaning of the...
So nobody has been dishonest?
Not within the context of the statute.
No? Well, what else have they done wrong? What have they done wrong? No one's been dishonest. No one's tried to achieve any inappropriate advantage. No one's been concerned to knowingly produce a problem for the registrar or the registration. Where's the problem?
We submit, Your Honour, there isn't a problem with this mortgage as such. There might be an underlying fraud in the sense of common law or equitable doctrines, but that does not pertain to this case.
So nothing's happened here?
Not in regards to our factual situation.
Nevertheless, the finding of statutory fraud was inevitable. The only one open.
It is the only one open that will defeat our client's indefeasible title.
The only one open on the evidence.
Or and on the evidence,
As you say, it should be a flood.
yes, that's correct. In dealing with the very issue as before this court tonight, Lord Lindley, on behalf of the board, said at page 210 that by fraud is meant actual fraud, i.e. dishonesty of some sort and not what is called a constructive or equitable fraud. And his lordship went on.
Well, that can't have anything to do with this, because you see, this is unique. You've just told us that. So you're not really going to get a lot of advantage by reference to authorities which deal with situations which are not unique.
I submit, Your Honour, this case simply for the purpose as a reference point to start the submission in regards to how does one define this nature of the statutory fraud, simply for that purpose. And Lord Lindley said that this fraud must be brought home to the person whose registered title is seeking to be impeached or his agents.
Why? Because you've just told me a while ago that we're concerned with the registration process. We're talking about the fraud being the fraud against the registrar. What's it got to do with anybody else?
Against the register by the person who lodges that document, and it might be in that case it's the mortgagee who is lodging that document or his agents. Therefore, it's the
If these people are also included in this notion of fraud, why aren't the broader concepts which are applicable to them encompassed as well?
broader concepts of equitable and common law fraud. Because the courts in the Court of Appeal and Victorian Supreme Court have confined,
If we don't recognise it.
if the court chooses to take the approach of the Victorian Court of Appeal, which is not binding on this court, but we submit that being the highest court in the state, to have construed that act which is governing the parties tonight, the court should take or acknowledge those judgments in some sort of way. We submit that dishonesty is the essential element of this actual fraud, and without it, the actual fraud cannot be made out. Again, in the case of assets, Lord Lindley drew a very important distinction between the persons acting dishonestly and those acting dishonestly. At page 210, towards the bottom of that very paragraph, his lordship said that a person is not guilty of the in saying that the standard of what constitutes honest conduct is not subjective. He held that the individual is expected to attain a standard which would be observed by an honest person in that same circumstance. An honest person would not be someone who would knowingly deceive another person. An honest person would not knowingly take someone else's money and spend it. Therefore, what the court needs to do is place an honest person in the shoes of, in this case, the clerk.
But he has to know that he is not attaining the subjective standard.
subjectively, Your Honour.
He's got to subjectively appreciate that he's not meeting an objective standard.
That would be very difficult to marry.
I know.
That's very difficult to marry together.
I'm not suggesting you ought to be able to provide an answer. I'm just curious to know how one actually does this.
Lord Nicholas of Birkenhead suggested you simply look at what an honest person would do.
I would ask him.
So given that we're concerned with a person's dishonesty, whose conduct should this honourable court be concerned with? We submit that the Act is concerned with an interaction between the person lodging the mortgage and the registrar of titles, and that the transactions which underlie the mortgage are not relevant to the actual registration of the mortgage. Section 74(1) requires simply that the person lodge a mortgage in an approved form. Unfortunately, this is not described within the Act as to what an approved form is. You simply take a document to the registrar of titles and ask him for his acceptance, and then you can use that type of document. My learned friends seek to rely on the fact that there is no written contract, and therefore the respondent's title cannot be relied on. However, the mortgage in this case is a creature of the statute. Section 74, subsection 2 of the Transfer of Land Act provides that the mortgage, when registered, takes effect as a security over a debt, but it does not operate as a transfer of that land. Accordingly, under the Torrens system then, there's this distinction between the mortgage which creates the charge, and by the very act of registration, confers an interest to the mortgagee. And on the other hand, the personal covenants which underlie that mortgage between the respondent, or the appellant in this case, and the respondents. This principle can be found in the very case that my learned friends have referred this court to, the case of Horvath and Commonwealth Bank of Australia, which was cited in 1999 and recorded in Victorian courts at page 643. Justice Phillips said at page 662 that one may distinguish between the personal covenants in the mortgage, the contractual part, and the creation of the interest in the land in the mortgagee, the conveyancing part. We submit that, given the reasoning outlined by Justice Phillips, the fact that the contract here was simply verbal and might not be satisfied by Section 126 of the Instruments Act, does not help the appellant's case whatsoever. It's the mortgage document that itself has to be in writing, and when lodged with the registrar of title, confers the security interest over the document, but does not transfer that interest in the land. The relevant conduct we submit is that of the person who lodges the document for registration, and no other person. And it's that person that must honestly believe that the mortgage is true and genuine. The relevant principle was stated by Your Honour Justice Hayne in Vassis's case, and followed by Your Honour Justice Hayne as a member of the Victorian Court of Appeal in Pyramid's case. Your Honour Justice Hayne having held in Pyramid that the title obtained by a mortgagee on registration under the Transfer of Land Act cannot be defeated on the ground of fraud if the mortgagee was not privy to or party to that fraud. It was further considered and affirmed by the Victorian Court of Appeal in Rousseau's case. Justice Ormiston, in agreeing with Justice Ormiston, Justice Batt said at paragraph 55 that this fraud must be sheeted home, that the mortgagee, the person with the registered interest, must be shown to be infected by it or complicit in it. Therefore, we submit that unless the person lodging the document has engaged in fraud, or their agents have engaged in fraud, that person acquires an indefeasible title, and that if the fraud of another party to the mortgage cannot defeat that person's interest. Your Honours, on the facts, the respondents themselves clearly did not lodge this document. So in the absence of fraud by the agent, the respondents have acted in good faith. Accordingly, there was no actual fraud on the part of the person who sought and obtained registration. On the facts, Your Honours, the mortgage appears to have been lodged by the agent of the respondent. The question, which this court has to answer, is whether the conduct of the work experience itself was dishonest. And given that our submission that dishonesty is equated with conscious impropriety, we submit that the essential element of dishonesty cannot be attributed to the work experience student. She was not sufficiently trained to appreciate the consequences or the significance of her false statement, and objectively, her conduct cannot be equated with conscious impropriety. And without this conscious impropriety, you cannot have actual fraud within the statutory context.
Yes, thank you. Your time has expired.
Thank you, Your Honour.
Before we hear Mr. Morocco, the matter of the reply is in the discretion of the court, is that right? Yes? 2 minutes, Council may anticipate being given 2 minutes reply on each side. Yes, Mr. Morocco. Come to the rostrum.
If it pleases the court, in our remaining submissions, we'll deal with the registration of the respondent's interest in light of the Confiscation Act 1997 of Victoria. Your Honours, in our view, there are 3 issues which are raised by the First Head of Appeal. These issues are outlined in the respondent's written submissions. The first issue contains a question of priority between the Transfer of Land Act 1958 of Victoria and the Confiscation Act. We submit that Section 3 of the Transfer of Land Act expressly states that the legislature's intention is that this Act takes priority to the Confiscation Act in matters which affect land under the Confiscation Act.
But to speak in terms of priority between the acts necessarily assumes a conflict. Do you accept that the 2 acts cannot sit together?
Your Honour, the respondent submits that Section 3 provides a presumption of interpretation. However, we are of the view that there is no conflict between the acts. That the Confiscation Act, as the second submission will deal with, sits well within the Transfer of Land Act.
The provision, that section 3, subsection 1,
Yes,
that
Your
was in the legislation a long time before the Confiscation Act was introduced, wasn't it?
Yes, Your Honour, that's correct.
Surely it's to be interpreted as applying to the law as it existed at the time of passage of the Transfer of Land.
Your Honour,
Something which in other circles would be called an originalist interpretation.
the language of Section 3, subsection 1 of the Transfer of Land Act states that if another act, in short, if another act applies to land unless expressly excluded by necessary implication excluded, that act will apply subject to the provisions of the Transfer of Land Act. It's the respondent's submission that Section 3 was introduced by Parliament with a view to apply to future acts insofar as they are not contradicting the Transfer of Land Act and repealing certain provisions by necessary implication due to that conflict. If the court...
Strange notion, because copies that go to the like at a later point of time, including repeal section 3.1.
Your Honour, it is a strange notion. These are the ways of Parliament.
But they're strange anyway. Then we understand that.
If the court pleases, I would like to refer to the case of South Eastern Drainage Board of South Australia and the Savings Bank of South Australia, which was reported in 1939 in volume 62 of the Commonwealth Law Reports, page 603. Your Honour, we believe that this case sheds light on the aforementioned submission. This case concerns the conflict with the Real Property Act of 1886 of South Australia, which provided...
stands for in terms of your argument.
Yes, Your Honour. Their Honours Justices Dixon and McTiernan found that Section 6 of the Real Property Act of South Australia, which was akin to Section 3 of the Victorian Act, except that it did not make provision for implied repeal by Parliament. They stated that it was a direction from Parliament concerning the interpretation of future acts. Their Honours were of the opinion that the intention of Parliament should form a relevant consideration of the court in interpreting that statute. Justice McTiernan stated at page 636 of his judgment, in that case, that the section enacts a rule interpretation for acts which are not cast in the form which it prescribes. Yet if a subsequent act clearly manifested an intention different from the presumption which section 6 intended to supply, the presumption would be displaced by legislative intention. Your Honours, this mirrors the common law stance on inconsistent provisions.
But if you go to the confiscation, it's first as clear as can be. The Act proceeds from an assumption that there is a torrent system of registration of title under the Transfer of Land Act. See section 41(2)(c). 41(2)(c) of the Confiscation Act says that if, in effect, there's confiscation, the property vests in the Minister subject to every interest registered, notified or saved under the TLA. So the two acts recognise each other.
Yes, Your Honour.
So once you accept that the two acts recognise each other, how do you ever get to any question of contrary operation? What do you understand the contrary operation to be that is put against you?
Your Honour, the contrary operation of the Act is unclear, as we will seek to establish. Our learned friends have applied the law mistakenly. The respondent submits that Part 5, the effective forfeiture under the Confiscation Act, applies to situations where a forfeiture order under Part 3 has been issued, or alternatively, a civil forfeiture order under Part 4 has been issued. Under Schedule 1 of the Act, the respondent concedes that a forfeiture order is possible, but on the facts of the case, a forfeiture order wasn't granted. Secondly, a civil forfeiture order, Your Honour, is recognised in Schedule 3, and according to the facts, Your Honour, such an order would not be applicable. The relevant order was made under Part 8 of the Act, Part 8 being being a pecuniary penalty order, And the pecuniary penalty order is different in character, although it serves the same end goal as a forfeiture order or a civil forfeiture order. If it pleases the Court, we will now commence our second submission, which will consider how the Confiscation Act affects the earlier Transfer of Land Act, and that they are not wholly consistent, or inconsistent at all, Your Honours. Part 8 of the Confiscation Act is the relevant part. It provides for the imposition of a pecuniary penalty order, which is an order made for an amount of money which is equal to the financial benefit obtained through the proceeds of crime. It's granted by the Court upon application of the Director of the Public Prosecutions or another authorised officer under the Act, and the Court then assesses benefits obtained by the subject through the commission of his offence and awards an order against that amount of money. On the facts, an order under Part 8 for at least $44,000 was made against Roberto Paglia, our client, and this amount from that time onwards, under the Act, and I refer, Your Honours, to Section 74, subsection 1, it represents a civil debt from that time onwards. The Court should note that the term civil debt is not defined within the Confiscation Act. However, we submit that the Parliament's intention is manifest in recognising this amount as a civil debt. We submit that the plain meaning of civil debt is nothing more than a general debt owed by one person to another. It's a civil obligation, Your Honours. Such a debt has no power of itself to override the principle of indefeasibility. A civil monetary claim never warranted the invalidation of a registered interest under the Transfer of Land Act, merely because that civil debt was incurred prior in time to the registration under the Transfer of Land Act. To do so would be to defeat the very purpose of the transfer of land. This is our submission regarding the plain meaning of the term civil debt, as was recognised as a principle in Cooper Brooks Wollongong Proprietary Limited and the Commission of Taxation of the Commonwealth of Australia, which was reported in 1981 in volume 147 of the Commonwealth Law Reports at page 297. The relevant quote is of His Honour Chief Justice Gibbs at page 304 of his judgment. The mistake my learned friends have made is that they have relied on Part 5, namely being referring to their written submissions, Your Honours, section 41, 42 and 43, all which deal with the effect, as already described, of a forfeiture order or a civil forfeiture order. Your Honours, the respondent submits that the relevant procedures for the enforcement of this civil debt, namely being the pecuniary penalty order, include Part 2 of the Act, namely Section 16, which empowers the Director of Public Prosecutions to obtain a restraining order from the court on all of the subject property, whether it be at the time the pecuniary penalty order was made or thereafter. On the facts, this has not been made. Had this order been obtained, the declaration of the court would then follow under Section 70 of this Act. This declaration would give the effect to make the property of the respondent in this case liable to satisfy the pecuniary penalty order. And the declaration would have brought into effect Section 72, subsection 7, subsection C of this Act, which states that under the Transfer of Land Act, a caveat may be lodged under Section 89 of the Transfer of Land Act by a person specified in the order. We submit that the enforcement procedure operates subject, therefore, to the requirements of the Transfer of Land Act. It does not override it, and there is no inconsistency. This is not a scenario such as was encountered by the court in the South Eastern Drainage Board of South Australia and the Savings Bank of South Australia, where in that case the statute, the latest statute being the South Eastern Drainage Amendment Act, introduced a charge which sat first on the register, regardless of any other charges, did not comply with the form of the Torrens legislation in South Australia, and it also provided a remedy in its own right, not subject to that Act.
What would it have to be the correct procedure to adopt here?
Your Honour, under the Act, a pecuniary penalty order doesn't at the time of application, nor thereafter, exclude the Director of Public Prosecutions from obtaining a forfeiture order.
So what does the Director then do?
The Director, in this case, would seek to regain control of the mortgage under...
How would he go about that?
There are two routes, Your Honour. Would you like me to deal with the pecuniary penalty order or the forfeiture?
You just tell me how he would go about dealing with that situation.
With the pecuniary penalty order, the Director of Public Prosecutions would apply to the court to obtain under Section 16 and 17 of the Act a restraining order pertaining to the respondent's property. This restraining order would then allow the court, under Section 70 of this Act, to make a declaration in effect to this mortgage. Section 70, once this declaration
would the court be empowered to do in making such an order?
Upon a restraining order, the court would be entitled to make a declaration under Section 70, which would be entered on the register, upon which Section 72 of the Act allows the Director of Public Prosecutions or a person so authorised by the court to go to the registrar, fix a caveat on the land and obtain further court orders to warrant the transfer of that land. From this period onwards, once the court has given its declaration under Section 70, under which the respondent brings to the court's attention that only the Director of Public Prosecutions or a person authorised under the Act may do. It may then be the case that the Registrar of Titles conveys according to the court's instructions, but not before.
Now, you've said there's another method.
Another method is under Part 3 of the Act, which is a forfeiture order. The forfeiture order is made in respect of a specific piece of property owned by the respondent, which is the proceeds of crime. It basically runs along the same route, Your Honour, and in that case, the effective forfeiture Part 5 would apply, which is what my learned friends had mistakenly applied to this case.
So then, it would have been possible to approach the court, seek the order, that would then have been given the power to the court to direct that in fact, effectively, the property is seized.
Yes, Your Honour.
I understand this argument. My question is how it relates to your previous argument. This argument is that the two pieces of legislation are not inconsistent.
Yes.
Your previous argument was that the Transfer of Land Act takes priority over the Confiscation Act, and that therefore implies that there is an inconsistency. Because why would priority come into it if there wasn't an inconsistency?
Your Honour, our first submission was pleaded in the alternative. If the court has no further questions regarding this submission. Finally, we submit that to find the registered mortgage invalid because of a pre-existing pecuniary penalty order, which is a civil debt, would defeat the very purpose of the Confiscation Act and the intention of Parliament. Section 1, subsection 8 of the Confiscation Act states the Act's purpose as to provide for the forfeiture of the proceeds of crime, whatever the form into which they have been converted. This is not impossible under the current Act and the current facts, Your Honour, just impossible in this particular case. In the second reading speech of the Victorian Parliamentary Debates in volume 437 of the spring session of 1997, the relevant Hansard for the Confiscation Act, which was referred to in my learned friend's written submissions, states...
Why do we need to look at this? Is the intent of the Act not clear on its face?
The intent of the Act is very clear, Your Honour. Your Honour, the respondent submits that the purpose of the Confiscation Act is to negate the toll that crime takes on society. It prevents criminals or people who partake in criminal acts from benefiting from the proceeds of their crime. And subject to strict enforcement procedures under the statute, the state takes away the benefits of these crimes that they engage in to compensate for the toll that it has upon society. Nowhere in the Act does it state that it is permissible for third parties to benefit from the proceeds of crime when they have been converted and temporarily escape the ambit of any forfeiture order that is made, whether it be under Part 3, Part 4 or Part 8 of the Act. We submit that invalidating the registered mortgage would give the appellants a $44,000 windfall, a windfall that they have done nothing to earn, that basically what they would be doing is taking the proceeds of the respondent's crime into their own pockets. Again,
You think it ought to be your
no, Your Honour.
I have a problem with this notion that somehow or other you're accusing there's some injustice in this.
Your Honour, the submission deals with the Confiscation Act.
I understand that, but you were becoming very rhetorical and I was almost beginning to feel emotional. So I thought I'd get it cleared out before I became upset.
That'd be a black letter lawyer for the minute you got that.
Your Honour, in brief, your emotion should be saved for the state because the state could not recover again if the appellant had it.
Thank you. Your time has expired. Mr. Fellman?
the registered interest of the respondent should succeed. As my learned leader submitted, fraud is not established on the facts. Furthermore, the intention of the legislature and the terms of both the statutes together indicate that indefeasibility should remain with regard to the respondent's interest. Thank you.
Yes, Mr. Farmer, 2 minutes.
The respondents construe fraud as only relevant if it's operative against the registrar. They use section 44, subsection 1 of the Transfer of Land Act in statements by Justice Hayne in Bassos for that purpose. Justice Hayne in that case said precisely the opposite, that section 44.1 does not limit the scope of section 42 in a way such that it should be read as only relevant against the registrar. I turn to His Honour's judgment in that case, where he said that section 42.1 provides a general rule of indefeasibility subject to an exception for cases of fraud on the part of the person making registration or his agent. And section 44.1 then deals expressly with the consequences that are to flow with respect to the register. I consider that the better construction of section 44.1 is one that reads the section not as qualifying section 42.1, but as stating the consequences that are to flow from section 42.1. Section 44 has nothing to do with the scope of fraud. It has nothing to do with whom the scope of fraud is operative against, but merely the consequences that flow once fraud has been made out, namely that the registration is void. Moving briefly to the question of section 3 of the Transfer of Land Act and the effect of that. The respondents claim that section 3 prevents any claim of inconsistency because it preserves the primacy of the Transfer of Land Act. In the South Eastern Drainage Board case, which was heard by this court in 1939, the court unanimously decided that since section 3 does not concern the constitution, powers and procedures of Parliament, it could not limit the ways in which Parliament would seek to legislate, thereby allowing Parliament to legislate inconsistently with the Transfer of Land Act. If there is a legislation inconsistent with the Transfer of Land Act, then that legislation will take effect, notwithstanding the fact that it does not use the express words required in section 3, because section 3 simply cannot do that. The reason that the acts were inconsistent in that case, and the acts were inconsistent in that case, is because the drainage, the subsequent act, effectively could not be useful in any sense if indefeasibility were to take priority. In this case, the same thing is occurring. The Confiscation Act simply could have no important effect whatsoever if indefeasibility would protect properties from being subject to confiscation. As such, the two acts are inconsistent, and the indefeasibility provisions must be read subject to the confiscation orders. Thank you.
Your Honour, in simple reply to my learned friend's submission that we have submitted incorrectly in regards to Justice Hayne's comments, I may refer Your Honours to page 327 of that very judgment behind tab 1, part A, tab 1. And His Honour said that if section 44.1 is to be read as avoiding entries on the register resulting from instruments in connection with which any of the parties had acted fraudulently, it would represent a significant and additional inroad on the indefeasibility created otherwise by section 42, and would render the limitation on the exception of the operation of section 42 to cases of fraud by the party seeking registration an unnecessary limitation. In other words, it would be an inroad to the concept of immediate indefeasibility as decided by the court in Brest-Ryan Law, and come down to reinstating the idea of deferred indefeasibility, which is not an issue before this court tonight. However, we submit that we have correctly submitted to this court the judgment of Justice Hayne, which was again affirmed by the Court of Appeal in the Pyramid's case. Finally, if I may quickly distinguish my learned friend's submission in regards to AGC and Diego, it was on the facts clearly found by that court that the employees of AGC knew that there was a false attestation, and furthermore there was other evidence to prove that they knew that this was incorrect, and therefore that's why the court held in that case to submit the document knowing the consequences of that false attestation was dishonest and therefore amounted to fraud in the circumstances of the statutory context. And therefore AGC is not applicable in regards to this case, but the Russo case strengthens our argument, Your Honour, in regards to comments by Justice Augustin and the fact that those legal technicalities are not something that a student would understand, that a 19-year-old law clerk would understand, let alone our mere work experience student who's learning the ropes of the law and has not been in the field for 3 years. Thank you.
Well, in a minute or two we'll adjourn. As I understand it, we'll meet again over at Owen Dixon Chambers when the winning team will be announced and also their speaker. Before we adjourn, I would like on behalf of the court to thank counsel for their assistance and to congratulate each one of you on your efforts. It was all done to a very high standard, in my opinion. And I shall not forget the instructing solicitors to make the ammunition to be fired out of the guns. Also, it's clear that the preparatory work in this case and the preparation of the briefs has been very well done indeed. So I'm not quite sure what time it will be when we resume over Owen Dixon Chambers, because to a degree we are dependent on how the other vote is going, whether that's concluded or not. So, yes, Judge.
I'd like to say something. I've pushed every one of these people pretty hard. And I think they have every right to be proud of themselves. I asked them totally off the wall questions and tried to throw them on several occasions. And they handled me beautifully.
And sat too long in the crowd.
And I think they did very well. Thank you very much.
All right. Well, thank you. We look forward to seeing you in quite a short time over at Owen Dixon Chambers. Thank you.
All stand and remain standing.
All four speakers spoke very well, dealt with a problem which was very difficult, and dealt with it in a way which reflects the fundamental point, often enough forgotten by counsel, that it is to the legislation that you must go for the beginning, some of us would say the beginning and the end of the problem, not elsewhere. Now, all that being said, thank you for your participation. Thank you for allowing me to participate in it. The best individual speaker and the recipient of the John Phillips Advocacy Award, which it was intended he should present, was junior counsel for the respondent. Yes. Trophy for the winning team.
The President of the Court of Appeal. Oh, you want...
I wanted to take this opportunity to say thank you to everybody here. We're very fortunate to have a competition which is supported by the judiciary, the profession, the faculty, students and the community in general. The skills that are learned and the knowledge that is gained in this competition is invaluable, as I'm sure that all the competitors will attest to, and looking around the room seeing previous competitors and previous winners, I'm sure they will attest to that as well. Each year with the Moot competition, and this is my the 5th grand final that I've been fortunate enough to come to, each is unique in its own special way.
And I'll never forget a number of years ago, Justice Hedigan saying to me that, Mr. O'Mahony, your argument was spoken like a true Irishman. The temptation to say to him that...
unintelligible.
The temptation to reply with, it's the vibe of the thing, Your Honour, was overwhelming. As I'm sure watching the junior grand final this year, I'm sure everyone will be wondering whether the bench does believe that flirting is an everyday activity. But this sort of competition can't be run without the dedication of a number of organisers. Our organisers this evening, Caroline Cook and Nick Dragolovich, have worked since the start of the year in organising this competition, and the amount of work that they put in is extraordinary, and I'd like to hand over to them, but could you please join me in thanking them for their organisation.
First of all, I just want to say a couple of thank yous. First of all, I'd like to thank the competitors and congratulate the competitors, all the competitors that took part tonight, and they've had to go through a couple of rounds and quarterfinals and semi-finals, and I think they all deserve a round of applause for their achievements. Second of all, I'd like to thank all of our judges on behalf of coming. It's a great commitment. They obviously have quite significant workloads themselves, and for them to come out after hours and judge students and mooting really makes part of the competition what it is. It's a very important part, and we're very grateful for all our judges that have taken the time and been able to come out and take time from their commitments to come and judge tonight, so we'd also like to thank them.
And now we'd just like to invite the Honourable Justice Winicky, who is President of the Court of Appeal, to announce the winners of the Junior Moot.
Well, thank you very much. We too have had a very enjoyable night listening to those who have been participating in the junior final. Monash itself has a very proud history of mooting. And it's interesting when we look around the various law schools that we now have in Victoria to see that each has developed its own personality effectively, but Monash has been in the forefront of training people in a practical way. And mooting, of course, has been one of the ways in which they've achieved that. Tonight, I think, is probably the 3rd or 4th or 5th or 60th moot that I've had the